All right, good morning, everybody. We're going to give it another minute or two here. We still got people joining. So another minute or two and we will get going. So thanks for joining. All right, good morning, everybody. Well, why don't we get going? We still got a couple people joining. But we're fortunate today we're going to have a class on navigating the new real estate forms. Obviously, that's a really hot topic right now. If you have, we're in a webinar, so you are all muted. But if you have questions for Brian, our instructor here, feel free to put them in the chat. I'll kind of monitor them and interrupt every so often and make sure your questions get answered. Certificates will be out probably first part of next week at the very latest. So we'll be sure to get those to you. And again, I'm Steve McDonald, Deschutes Title Company. So happy to have Brian Beck. He's going to educate us here a little bit on the new forms. Quick little bio about Brian. Brian's been practicing civil litigation for 19 years with a focus on areas of contracts, contract enforcement, business litigation, trust, and estate litigation, and real property matters, including purchase and sale, boundary disputes, easements, and title issues. Born and raised in Rapid City, South Dakota, Brian brings a down-to-earth ability to distill complex information into written and verbal language that clients, opponents, judges, and juries can easily understand. He combines a creative soul with an insatiable natural curiosity and keen analytical abilities, a synergy that proves highly useful in the advocacy process. Brian loves to move, so when he's not working, he's hiking, at the gym, or touring the country with his wife on their Harley. Brian is an avid guitar player and is part of a local three-piece hard rock band. So I don't know if you're going to play for us, Brian, but hopefully we'll educate
You never know.
So with that, I'll turn it over to Brian Beck of Obsidian Legal. Go ahead, Brian, all yours.
Thank you, Steve. I did write that bio, so Steve didn't make that up. That was a good introduction. I appreciate it. So we need to get into it because an hour will go by quickly, at least based on the notes that I made. So my goal here is to do kind of a deep dive into a few of the documents that have come out. There's a lot of great information that's out there, and I don't want to repeat what that is. My main resource for learning kind of about the context was OregonRealtors.org. So it's the website OregonRealtors.org. They have forums available there. They have a hotline for questions from agents on these documents. So they're happy to take your calls, happy to answer questions. So they're a great resource, and I actually talked to the internal counsel there for some thoughts on these things. Good guys, very helpful. So again, I'm using the Oregon Realtor forms. There are other forms available, but these are what I'm using today. In order to stay on track, I'll only mention that the changes are prompted by settlement or by the settlement in litigation involving the National Association of Realtors. The cases are antitrust in nature, and the settlement does bring about some changes to the way realtors do business. And fortunately for us and you, those changes are incorporated into these new documents. So along with the settlement agreement, Oregon passed House Bill 4058. And the primary matter with that was to mandate the use of these buyer agency agreements. So the agreements are new, and from what I've understand in talking to my realtor friends, there's a lot of questions about them. And so what we're going to talk about, what I'm going to do that is hopefully different from what you've seen, is just go through these documents. We're going to go through them, the provisions, not every line by line, but we'll go through a lot of the provisions line by line and kind of discuss the meaning of some of the language and the legal consequences where applicable. And so if you have questions, please feel free to ask, and I will answer what I can. It will be hard for me to give you any kind of information as to, why the changes were brought about or any of that kind of more inside knowledge. But I can certainly lend my perspective as a lawyer who does a lot of work in contracts. So I think the good people at Deschutes Title emailed you some documents. Hopefully that's the case. If you would open up 9.4, it's the buyer rep agreement, and we'll start with that. So obviously you're going to state the parties. I won't discuss some of the more obvious things, but I do want to comment on number 2, purpose. And that's one of the great things about these documents that I encountered in going through them. And that is they're written to be as clear as possible and to provide as much guidance as possible and to eliminate judgment calls to the extent possible. So all those things are wonderful for you, and they're wonderful for the parties, because the goal of a contract is not only to state what each party is supposed to do. A good contract will state why. Because what a contract is a memorialization of the party's understanding of the contractual relationship. So anything that helps contribute to the understanding can also help contribute to the reduction or elimination of any problems down the road. So all that is a good thing. And again, I find these documents pretty darn well written. I did find an error in this document this morning, though, and I emailed counsel at Oregon Realtors just to confirm that it was an error, and it was. So I'll touch on that here in a little bit. So the purpose, again, this is where we state the party's intent. This is what this relationship between buyer and agent. Paragraph 2 states what this relationship is about. Number 4, buyer acknowledgement. This is an example of language that protects the agent. So you'll find that throughout these documents where for example, there's language saying that buyer hasn't relied on agent. And that, of course, puts any risk back on buyer. In this section, agent is not an expert in legal, zoning, financial, construction, engineering, or environmental health and safety matters. And agent has no duty to investigate matters outside of agent's expertise. Agent cannot guarantee accuracy of information received from third parties, nor the confidentiality of information given to third parties. So again, that is very protective of the agent. Going down to 6, line 40, duties of buyer. And this again clearly states what the expectations are for the buyer. And these provisions are actually quite similar to what I have in my fee agreement. So my lawyer-client fee agreement has very similar provisions. And again, all this is to put everything above board so that everyone knows what the expectations are. And then, of course, later, especially in the PSA, there's the dispute resolution mechanism that will come up if any of these are breached or if there's any kind of problem. Paragraph 7, we're on line 53 now. The term of the agreement is limited to 24 months. You can make it as short as you want, but you cannot make it longer than 24 months. If 24 months elapses, the agreement will expire, and then you can execute a new agreement, or ideally, on the day before the expiration, so there's not a lapse period involved. Paragraph 8, line 57, compensation. This is one of the hot topics. And in speaking with one of my realtor friends, there was a question as to how 59, 60, 61, 62, and 63, those lines, how they apply. So the first line, going back to the top of the provision, though, agent's compensation for services rendered is fully negotiable and is not fixed, controlled, or recommended by law, Oregon Realtors, the MLS, or any person not a party to this agreement. So what that means to you and the buyer is that these are fully negotiable. The terms are open. Nothing is dictated. And that's, again, the nature of contracts. Contracts are supposed to be a memorialization of the party's intent. So whatever that intent is, as long as it's legal. So looking at line 59, this is the financial arrangement between the buyer and buyer's agent. There's a percentage of the gross sales price or a flat fee. That's 60 and 62. And then 63 is other compensation arrangement. So in speaking with some realtors, I had a chance to review some of the language that was written in. And I found some risks, some areas where it might not quite do what they intended it to do. So if you intend to use line 63 and write in some other compensation agreement, I highly recommend that you talk to an attorney about that, because these are legal terms, they have legal consequences, and these consequences could affect your fee. So it's very, very important. Line 66 states how the fee is triggered. So 1, buyer's acquisition occurs within the stated terms of the agreement, or the stated term, meaning time of the agreement, and buyer has not delivered written notice of termination. That's one condition. The other is buyer's acquisition occurs within X. So that allows you to extend beyond the term of the agreement. And again, it's contractual. So if that's what you and the buyer agree to, you can do that. And I'll note here too, that in a legal sense, the use of "and" in these agreements is very, very important. And alongside with that, the use of "or." So, and if there's a set of conditions that is linked by an "and" agreement, all of those conditions must be satisfied for that next event to occur. So in this example, agent is entitled to a commission if, and number 1 has acquisition occurs during the term and buyer has not delivered written notice. So both of those things must occur for that provision to apply to trigger the availability of the fee. Number 9 on line 81. Seller contributions, and this is also a hot topic. So again, I'm looking at what's written here. I don't have inside knowledge as to what the drafter's intent was necessarily, but I do feel like the drafters expressed that intent pretty well. So there are 2 ways in which buyer's payment obligation to agent in Section 8 may be offset by seller. So here they're telling you there's 2 ways to do this, and then they provide each of the 2 ways. Again, the language here to me is pretty darn clear. They do a real good job. And I'll take a second to note too, that Oregon Realtors especially, I did talk to internal counsel on these, and they are in large part responsible for the drafting, although they rely on other people, including realtors too, principal brokers, other people in the community for their perspectives. So I think they're written very nicely in terms of being able to be understood and followed. So per the agreement between seller and listing agent, the listing agent may share a portion of listing agent's compensation with buyer's agent. That's cooperative compensation, as you know. Cooperative compensation agreement must be entered into before buyer submits buyer's offer. So the goal there is to get everything above board before anybody executes any contractual documents, including an offer, because as you probably know, once an offer is accepted, you have a deal. So the goal is to get all of this above board, all of this covered. It does a couple of things. It provides for that arrangement with the knowledge of the parties before you enter into a contract, and it protects everybody as well. It eliminates questions that would likely arise if they had not been executed. Agent shall disclose to the cooperative compensation agreement to buyer prior to submission of buyer's offer. The seller, this is number 2 now, the seller may contribute toward buyer agent fees, seller contribution, which buyer can request in buyer's purchase offer. So that's the place to basically request. I mean, you write it in as it allows. And so that's your request for the cooperative compensation. And then if they agree to it, great. If they don't, they will probably execute some kind of an addendum or the cooperative compensation agreement that's referred to in section 1 directly above. And starting on 93 at closing, the cooperative compensation and seller contributions, if any, shall be credited against buyer's payment obligation in section 8 above. Buyer shall be responsible for paying any remaining amounts owed under section 8. And again, in the legal context, the use of shall opposed to may. Shall is mandatory. It means that the failure of that statement or condition, whatever it's trying to achieve, if that is not complied with, then there will be some kind of a consequence, whether it constitutes default or some other kind of failure. But shall means mandatory, it means must. Agent may not accept total compensation payments from all sources in excess of the compensation agreed to in section 8. So the buyer's agent is limited. They're stuck with whatever amount they have. So even if seller offers a higher percent, the agent is bound by this contract that they have with their client, with the buyer. Termination. So like the PSA, there's a termination provision here. This section provides for the termination that kind of marches through the procedure for it. These forms are really good about applying dates. So there's often 2 check boxes is what you see frequently. One checkbox states a finite term, 2 business days, 5 business days, and then a second checkbox will allow a write-in. Although that's not in this provision, but you'll see that throughout. So in the case of a termination, if buyer unilaterally terminates prior to the end of the term, buyer shall pay an early termination fee of an amount to be determined by the parties. So again, this is contractual in nature. It's subject to negotiation. You may use it, you may not. It depends on your situation with your buyer. Going to the next page, line 100. If buyer unilaterally terminates this agreement before the end of the term and buyer acquires a property within the time frame and on the terms described in section 8 of this agreement, agent will be entitled to the compensation amount contemplated in section 8 minus the early termination fee. So it's again an interesting legal question, and I wonder if you understand. Do you guys understand why that is so? Why you're not allowed to take both kinds of compensation? I'm sure you do. So my perspective is that if you take the compensation affirms the contract. while the fee operates kind of as a penalty. The early termination fee disavows the contract. So one type of compensation, you want to press through with the contract. The other kind of compensation, you're ending the contract. So you can't have both types of damages. It's similar if someone files a lawsuit. If I file a lawsuit for a client in which we're dealing with the terms of a contract, and the client has the option of forcing the other party to do what they're supposed to do, which of course is specific performance, that remedy is exclusive of damages. So you can have either damages or specific performance, but you can't have both, because one affirms the contract, the other disavows the contract. The next provision, number 11, dispute resolution. They've done a real nice job with this too, I think. It states that the exclusive remedy, the exclusive procedure to use is, one, small claims court, if the dispute is 10,000 or under, or if it's not within the jurisdiction of small claims, then through mediation and then arbitration with ASP in Portland. So I actually had a mediation with ASP yesterday with Kevin Ike. If any of you guys know him, I really enjoyed. He did a fantastic job. So it's nice to see them getting the business. Then the prevailing party also has the ability to recover their attorney fees. So that's a real important provision. It eliminates some of the risk. You know, that the motivation with attorney fee provisions is that the legislature, the courts want people to be able to bring meritorious claims. So if you have a meritorious claim, they want to encourage attorneys and clients to bring those claims, even when the client may not have sufficient funds to press all the way through. So that's kind of the goal there. It's to help people in achieving remedies for meritorious claims. Then, of course, there's a statute that's available for non-meritorious claims, which is a different story altogether. So the error that I was talking about is in this number 11. So we just got done reading through the text, which says small claims is the exclusive process by which to bring claims $10,000 or under. Then if you go to 116 or 115, the following matters are excluded. Then item 1 on 116, excluded small claims. Well, that makes no sense, right? So that is an error that was just inserted by the drafters, and pointed that out to Oregon Realtors, one of the attorneys there. And he said, yep, that's an error. So these things are living documents, and contracts are always living documents. They're always subject to, you know, once you've executed it, you can't make unilateral changes, but you can make mutual changes if that's what you want. And, you know, I have various contract forms, settlement agreement forms, things like that. And I always am tweaking, I'm always updating, I'm always making them better. So that's what I mean when I say these are living documents. And finally, line 121, buyer has been advised to seek independent legal counsel to understand the provisions of this agreement. That's an important piece too. Again, it protects agents. It provides another recommendation to buyers. And this one is in all caps. So we mean it. They should seek independent counsel. The agent should refrain, as you very well know, from giving anything that even smells like legal advice. So if you have a question, call an attorney. All right. Does anyone have questions? Steve, are you getting any questions about this buyer rep agreement before we move on?
Nope, I haven't seen a single question, so I'm
Okay.
not sure if I'm doing something wrong or it's just
All right.
out there.
Well, I'm going to keep yammering. The next thing we're going to look at is 1.1, which is the PSA. And again, important terms to look at, they seem like passing words, but they're critical words. Shall, may, and, or. These things are all things to keep your eye out for. Because if you have an and that links two conditions and you only perform one condition, well, then the condition is not satisfied because it's combined with the other condition. So provision 1, buyer and seller acknowledge that they have read and understand the Oregon Realtors buyer and seller advisories respectively. Again, a cautionary statement to buyers and a protection for agents. If seller wishes to sell buyer, I'm on line 7. If seller wishes to sell to buyer, but information about seller or property is inaccurate, seller should not accept the offer as written and should submit a counteroffer with the corrected information. So this is important because I think, when I'm filling out forms, a stack of forms like this, if I don't know what I'm doing, I'm assuming that everything's accurate. And so that assumption, if that's what the buyer or the seller is doing, then that assumption is not going to fall on the agent, provided the agent didn't make some kind of a representation. But these documents are replete with examples where we're reminding buyer and seller that the burden's on them to do your due diligence, read things, understand them, consult counsel if you don't understand or if you need clarity. And in this case, if something is not accurate, don't accept it. We're telling the buyer this or the seller this on the offer sheet. If there's something that's inaccurately stated, seller needs to change it. So these kinds of provisions really should go without saying, but again, they're for the benefit of these lay people. So it's important for them to understand that these are legal documents with legal consequences. So accuracy in all these aspects, accuracy is critical to ensure, once again, that the party's intent is being realized. The financial terms, section 4, starting on line 20. This again is super straightforward. There's really not even any explanatory language needed. It just marches you through a process. So you fill in blanks, check a couple boxes, fill in the blanks. 4F, seller. So this is an interesting set here. 4F, 4G, 4H, lines 27 through 32. 4F, seller to pay buyer brokerage fees to buyer's agent's firm at closing in amount of or percent of purchase price. So that is the flat fee or a sum certain or a percentage. For G, seller's agent's firm has separately agreed to pay buyer brokerage fees in similar amount. However, 4G has an asterisk by it. So initially, this reads like an either or, right? It seems like either seller's going to specify what they're paying in F, or there's going to be a separate agreement under G. But G has the asterisk that clarifies that it is for informational purchases only. So if you go down to line 34, that's where the asterisk is explained. Informational purposes only. So what does that mean? Well, it will play itself out. But what I read, and don't take this as legal advice, but this is my reading of it. I think 4H comes in if you want to use 4G. It states that the total buyer brokerage fees will, it states the total buyer brokerage fees that seller will pay under either 4F or 4G. So if you have a 4G separate agreement, then you just state what those numbers are in 4H. And again, we have another agent protection on 35. Buyer attests that the line in 4H does not exceed the brokerage fee set in the buyer's representation agreement. Prorations, here we have a date, 7A on line 41. And this again, super simple, short, easy to understand. Line 43, number 9, included items. And there's more on this topic below. So this is kind of almost like a summary. So this is where the agent will describe anything that's included. You can B, you state what's excluded. So the goal again, to clearly state the party's intention so that there are no disputes down the road. No one feels sad or cheated, gets angry over a lampshade. Water sewer. So now we're on line 55. And this is provision 14. And I'm just pointing out another example of, a potentially legal term, but they have written it to remove as much judgment as possible. So seller represents that seller has actual knowledge. So that means they know with certainty. They have reason to know based on evidence that the primary unit is connected to whatever the choice is. So actual knowledge, in law, we have different kinds of knowledge. There's knew or should have known, which is grayer. That's always fact specific, and it requires the use of outside facts. This is actual knowledge though, so seller must actually know. Line 6722, additional provisions. This is where you would attach form 2.2, the general addendum, if you need more room. Otherwise, if it's a brief statement of additional provisions, write it in here. And moving on to section 23. It just occurred to me that these lines may not match up because I have written notes in here that move some of the text downward. So for example, I'm showing section 23 on line 74. And I don't think that's the case for you. But what I did want to comment on is, again, this is a nice, clear description of methods and procedures that enhance the understanding of the parties and clearly state the intentions. So 23, we're counting time, defines counting of time, similar to rules that we have for our civil procedure and law. Specific dates control, 24. 25 is the earnest money deposit. So it starts off with that some certain number of days or a write-in number of days, again, subject to negotiation. Buyer will deliver the earnest money. So skipping down a little bit, after the earnest money deposit deadline, and if buyer fails to deposit the earnest money, buyer's earnest money deposit fails due to insufficient funds, or buyer's earnest money is reversed by buyer or bank, seller shall have the following options. So it gives you the conditions under which this can be invoked, and then it gives the options that seller has. So the first one, can provide buyer with form 5.2, seller's notice of default, and that gives the buyer a cure period. So there are mutual forms, 5.2, 5.3. There are mutual forms, one for buyer, one for seller. And the idea here, again, is to get everything above board to the extent possible. And these forms allow the parties, if something goes a little bit wrong, if there's a default of some material provision or some failure by one of the parties, the notice of default says in writing that, hey, you did this. And it gives the other party an opportunity to cure that error or cure the failure. So that's an important piece too, in making sure that the transaction can continue. It resolves any issues now so that the parties can just move on from there. The second option the seller has available is to terminate. So if the buyer decides, if the seller decides to terminate, then they use form 5.4, seller's notice of termination. Now, termination operates with immediate effect upon receipt by buyer or buyer's agent or the other party's agent or themselves. So it's immediate, and it brings up another interesting kind of legal scenario. So if you intend to go for specific performance, don't use a termination, because the termination is effective upon delivery. So you can't both avow and disavow the contract. Again, the termination is to disavow the contract. It ends the relationship. If you want to compel specific performance, then the option for that, as I see it, is use the notice of default opportunity to cure. If the issue is not cured, then you can use the dispute resolution mechanism and bring an action in small claims or an action before a mediator or arbitrator to force specific performance. So all of this, again, it provides a pretty nice template to follow. And then with regard to the options to buyer here again, if seller goes straight to termination, seller gives up any right that they may have had to the earnest money. So the difference there is that with a notice of default, buyer has an opportunity to make it right. And of course, you're essentially depriving the buyer of the opportunity to make it right if the seller issues the termination notice straight away. Section 26 has another statement that places burden on buyer. Buyer represents that buyer is not relying on any contingent funds or non-liquid funds for down payment or closing costs, unless specifically set forth. So again, we're going for disclosure here. Everything to be above board, everything to be transparent and understandable for the parties. Section 27, financing contingencies. If the parties have agreed that buyer is purchasing the property with a loan, buyer's obligation to purchase the property is contingent upon. All right, so that means conditioned upon the happening of conditions that follow. 1, buyer and property qualifying for the agreed upon loan. And 2, lender's appraisal being equal to or greater than the purchase price. So they're connected by an and, which means they both must happen in order to trigger buyer's obligation to purchase. The other piece in that, to me, it kind of creates a question, well, what if buyer just, decides not to or doesn't for some reason? These documents don't say it, but it's part of contract law in general in Oregon that all parties or both parties have a duty of good faith and fair dealing. So both parties are obligated to behave and to do what is done in good faith and to avoid doing what is bad faith. So following down, still in 27, the next paragraph, buyer will notify seller within 2 business days or the negotiated or agreed upon number of business days after receiving notification from lender that buyer or property failed to qualify. So this triggers, again, a kind of a notice and response mechanism. So when buyer notifies seller that financing has failed, buyer may give seller a Form 5.3 notice of termination with all earnest money returned to buyer. So buyer's option that, that to me is useful if the financing is a hard no, and if they realize that this was their only shot at obtaining the money to buy the property. And if that fell through, then yeah, to me, it would make sense to just go straight away with the notice of termination. They get their money back, transactions over. But if it's an issue that can be overcome, the buyer may want to continue with the transaction. So in that instance, again, it would be probably best to avoid the use of the notice of termination. One of the things too that I gleaned from some of the presentations that I watched from Oregon Realtors, a good piece of advice was not to use the termination notice as a positioning statement. So it's not a good idea to use it as a threat, because it has actual legal consequence. When you execute that document, send it to the other party or their agent, it's effective. It terminates the contract. And if the termination is unauthorized or some other kind of way, a breach or default, then the other party can take action on that. I have written so many notes in here. Next, if buyer does not send buyer's notice of termination alongside the failed financing notice, buyer and seller may negotiate the terms of the agreement. So that's always open. Again, it's there to remind the parties that there may be other ways to complete this. You know, we're not bound by what's written necessarily. As if the parties both want to amend or modify this agreement somehow or introduce new terms, then you're free to do that. Use the addendum form. If buyer and seller failed to reach an agreement within a specified number of days after seller receives notification from the buyer or the property fails to qualify for the loan, then either party may terminate within 2 business days. And again, the way to terminate is using 5.3 or 5.4, buyers and sellers notice of termination. Indicating that all earnest money shall be returned to buyer unless buyer. So again, it's a conditional statement. The money by default goes to buyer unless if buyer misrepresented buyer's financial information. If buyer has failed to fulfill duties regarding financing described in section 26 after receiving the notice of default. So again, that falls into the opportunity to cure. Or 3, fails to give seller required notice during failed financing notice timeline. So in such an event of buyer misrepresentation or failure to comply with duties, seller has the right to the earnest money. So again, it states pretty clearly based on kind of a walkthrough, an orderly succession of statements and events, and then it directs you to the conclusion that is reached. So in that latter instance, seller has the right to the earnest money. Then just below, if neither buyer nor seller delivers a notice of termination within 2 business days, then the parties will be deemed to have approved the transaction without the financing contingency. And buyer will be deemed to have released buyer's rights under the financing contingency. So if neither party terminates, they're deemed to have approved without the financing contingency. Again, all of this points out really a critical need for the clients, for the buyer and seller, to spend some time reading these things so that there are no surprises. I know it's a big ask. In the past, I've been guilty of just, sign and flip page. I've done that too, but it's really important. And of course, I keep saying it, that these documents are written to promote the best understanding possible. And so they do a good job with that. Going down further on section 29. Unless waived in writing by buyer has the right to have the property and all its components inspected by Oregon licensed professionals, to have the property reviewed, surveyed, or otherwise tested for all matters affecting the suitability of the property for buyer's intended use. So then it goes on to talk about, well, okay, some inspections are invasive. That's covered here. Invasive inspections or tests or inspections by unlicensed persons must be agreed to in writing by seller. For purposes of this agreement, and then here's a little carve out. Purposes of this agreement, sewer scopes, mold tests, pest inspections, dry rot inspections, radon tests, and oil tank locates will not be considered invasive inspections. But buyer is responsible, and this, this makes sense, but nonetheless, it's a good idea to state it. Buyer is responsible for restoration of the property following any inspections performed on buyer's behalf. And of course, that's fair, but it bears putting into the contract so that if a buyer is unwilling to do that, well, they've agreed to it in the contract. Further down, buyer has the asserted number of days, which is the due diligence period, to complete all surveys, tests, complete all negotiations with seller over repairs, and some other stuff. So if buyer terminates the transaction pursuant to this section, all earnest money will be returned to the buyer. And this to me is interesting because the buyer is assuming a burden here, or assuming a limitation, a time limitation to complete this due diligence period. Yet there are things on which buyer is fully dependent on seller to complete all negotiations with seller over repairs. So if you get a seller who's, maybe they're in another country, or maybe they just aren't good at communicating. So at times then it can be, I would say it's stressful for a buyer to be limited by time when you have a seller who won't act. So again, seller has to act in good faith, and the parties are always free to modify or extend the due diligence period. The PSA then notes a little bit further down, the seller is not required to make the repairs. So if the parties agree and sign Form 2.5, the repair addendum or the general addendum, they can modify the payment terms in lieu of repairs. So whether that goes, it's reflected in the sale price or however the parties want to do it, fully negotiable, whatever works. Buyer's failure to deliver to seller assigned notice of termination based on an unconditional disapproval of due diligence items during the due diligence period constitutes buyer's acceptance. And so that is kind of a defaults to acceptance. If buyer takes no action, then they accept. Also, there's a provision at the end of the paragraph. Upon seller's request, buyer must provide a copy of any inspection report. So that's an interesting one too. Paragraph 30 is title reports, documents, and contingency. So within a business day after mutual acceptance, seller shall order or cause to be ordered a preliminary title report, together with complete and legible copies of all documents that will remain as exceptions. So the PTR by itself isn't enough under this PSA. What must be provided includes all other items that will remain as exceptions. So recorded easements, anything that's of record, any conveyance, any other, even CC&Rs are included in this. So those things will need to be included with the PTR or the amended PTR. Then it says a couple lines further down, unless waived in writing by buyer, this transaction is contingent upon buyer's approval of the PTR and the title documents. Buyer has, I'll just synopsize. Buyer has an agreed number of days to approve or disapprove. If there's an amended report, buyer is given another 5 days, 5 business days, or until closing, whichever comes first. If buyer disapproves in writing, then seller has an agreed number of days to correct any matters identified by buyer or provide assurances that matters will be corrected before closing. If seller fails to correct the items that buyer disapproved of or fails to give adequate assurance, buyer has 2 business days to give notice of termination to get earnest money back. So in that instance, the buyer is on a short leash in terms of time if they want to get their earnest money back. If buyer does not provide written notice of disapproval or termination within the allowed time, then, as before, buyer is deemed to have accepted the matters disclosed in the PTR. So inaction can have just as firm a consequence, just as binding a consequence as an action or a breach. Reading further down, I wish I could give you a line number, but we won't match. This is just below the boldface if buyer provides written disapproval of any items in the preliminary title report. So if we go a few more lines down from that, in the middle of the paragraph, it begins, if seller has failed to correct items disapproved by buyer or otherwise failed to provide adequate assurances that such items will be corrected prior to closing, within 2 business days at the end of the title correction period, buyer may give seller a notice of termination stating that seller failed to provide such corrections or assurances within the title correction period. And in that instance, earnest money goes back to buyer. Once again, right after that, buyer's failure to provide written disapproval and notice of termination within the time set forth. So there's 2 pieces to that. Provide written disapproval, provide notice of termination, and then within the set times. So there's an event that must happen, but it's also confined by time. In 31, and this is an interesting one to me too. And certainly something that bears knowing for a seller. Kind of buried into the paragraph, 5 or 6 lines down. Seller's failure to provide properly functioning and installed smoke and CO devices is a violation of state law and could result in fines and, if injury or death results, civil damages. So this is an extraordinary duty for a seller. It's contractual, but you know, if something bad happened as a result of seller's failure to provide these functioning alarms, the remedy that would be, they would be a defendant in a lawsuit, you know, potentially for wrongful death. So seller's breach could have catastrophic consequences. Risk of loss is an interesting one too, paragraph 32. Seller must promptly notify buyer in writing if all or a material part of the property is destroyed without fault of buyer and neither closing nor possession have occurred. Seller must use reasonable distance, shall use reasonable diligence to submit all claims and related information to the insurance company, and because it's an and, it's included with must promptly inform buyer of all relevant updates regarding seller's insurance claim. So then buyer is given the election at buyer's sole discretion to continue or not continue in the transaction. And again, the notification is done in writing, as everything always should be. If buyer provides a notice, then closing date shall automatically be extended for a reasonable period of time. Again, reasonable, it's intentionally vague because the drafters, you know, it wouldn't do to insert a time certain because we don't know what kind of loss or what kind of damage might fall upon the seller. So it could take 60 days, it could take 10 days, it could take 3 months. So that's the reasonable period of time will be subject to the parties' negotiation. Well, sorry, I misspoke, but in no case longer than 60 days. So that is overcomable. You could draft around that. So I would say in an instance, you know, this is default language, no case longer than 60 days. The parties may agree in the next line to a written contract outlining the terms and conditions under which buyer will remain obligated. So there again, it suggests, or it provides really the opportunity for the parties to negotiate some other kind of arrangement. If buyer does not give seller written notice of intent to proceed with the transaction, this is just a little bit further down, a couple lines further down. Buyer does not give seller written notice of intent to proceed and seller has not repaired all damage, or if seller fails to promptly notify buyer in writing of damage or destruction, seller cannot enforce the sale agreement. It cannot. And buyer may give seller a form 5.3 notice of termination. So that leaves it in the buyer's ballpark to continue with the transaction. What seller cannot enforce means to me is that they have no legal remedy to say specifically perform, to get an order from a judge or an arbitrator for specific performance. They don't have a right to enforce it. In this instance, buyer is entitled to a refund of the earnest money and to recover any portion of the purchase price the buyer has paid. So the buyer would get to be zeroed out, made whole. Going down a few more. Oh geez, we're almost done. Definition section is important. The takeaway there is, if in really any of these agreements, if a term is capitalized, that means it's a defined term. So sometimes the definitions are provided in the text where the defined term is, sometimes not. In this case, we have this section 36, and these definitions control. So they're telling you right here, this is the meaning of these terms. And again, you'll see them in the documents by their capitalization of the first letter. Hey, Steve, we're pretty much out of time. Do we have any questions?
Yeah, no questions. You
Okay.
must be covering it all. So if you want
Wow.
to wrap up here,
I'm
maybe a
doing
couple.
doing such a bad job that everyone's confused. I hope that's not the case.
No, I don't think so. If you want to hit on a few last good bullet points, we can
Yeah.
close out on that. And
Well,
if there's
the
any
other,
questions, throw them in the chat, please.
yeah. The other important pieces in this, you know, there are other documents that come into play. And all of these things are created to be used together. So any standalone document, of course, the mother document is always going to be the PSA, right? That's going to be essentially the contract. So we have things like the addendum is 2.2, property disclosure is 3.1, the buyers and sellers notices of default, 5.1, 5.2, notices of termination, 5.3, 5.4. And I believe that these were all emailed to you if you don't have them already. Seller's response. And another interesting piece is a response to termination is required. Even after you receive a notice of termination, by which terms the deal is dead, you're still required, or the party, the recipient is still required to respond to that. In the PSA, section 48, default, very important. It sets forth a really easy to follow, really simple set of procedures for dispute resolution. 49 is termination, escrow instructions. And really that kind of takes us to the end of the highlights as I have them. So I would love to have gotten through more of these things. If you guys are interested in going through more of these with me, let Steve know, and maybe we can put another one of these together. But we're just about out of time, so I'll let Steve wrap it up.
Yeah, appreciate it, Brian. That's great stuff. Thanks, everyone. We'll get certificates out to you here shortly, probably the next few days. And like I said, Brian's an expert on this. He's worked in title insurance, contracts, written all that kind of stuff with real estate. So he's a really good one to lean to. So it's Brian Beck, Obsidian Legal, and appreciate all of you being here. Thank you.
Thank you.